Lisa Niedermeier had always wanted a Jeep Wrangler. There was something about it, rugged, open sky, built for adventure. She saved carefully and in 2015 drove one off the lot for about $40,000, feeling like she'd finally earned something good. Within weeks, the Jeep started making noise. The Wrangler soon developed transmission, engine, and exhaust problems, jerking, rattling, grinding, and noxious gases seeping into the cabin. She brought it back to the dealer. They fixed it, or said they did. She drove home. The rattling returned. She brought it back again. And again. Over the following years, Lisa gave FCA, the manufacturer, formerly known as Fiat Chrysler Automobiles, more than a dozen chances to fix the vehicle. In total, she returned the Jeep 16 times over 4 years. It sat in service bays for 75 days. California has a law for exactly this situation. The Song-Beverly Consumer Warranty Act, better known as the Lemon Law, says plainly that when a manufacturer can't fix a defect after a reasonable number of attempts, they must either replace the vehicle or buy it back. Lisa knew her rights. She asked FCA to repurchase the Jeep. FCA said no. They refused to accept the return of the defective Jeep or offer a refund of the $40,000 she paid for it. Faced with no good options, Lisa traded in the Jeep at an unaffiliated dealership, receiving a $19,000 credit toward a new, working vehicle. Then she sued. The jury sided with Lisa. They awarded her the full purchase price of the defective vehicle, plus incidental and consequential damages, and a civil penalty. It was a clear victory, or so it seemed. FCA appealed. Their argument was that Lisa had received $19,000 in trade-in credit for the Jeep, so any damages owed to her should be reduced by that amount. The Court of Appeal agreed and sliced nearly $19,000 from her award. Lisa and her attorney decided that they would not let FCA get away with it. They took the case to the Supreme Court. In 2024, the California Supreme Court reversed the appellate decision and ruled in Lisa's favor. The logic was straightforward. A manufacturer cannot claim a damages offset for a trade-in value when it was the manufacturer's own willful refusal to honor the Lemon Law that forced the consumer to trade the vehicle in the first place. In other words, you don't get credit for a problem you created. This Supreme Court decision strengthened the law for every California driver who would come after her. Lisa Niedermeier had wanted a Jeep Wrangler for adventure. What she got instead was 4 years of repair shops, court filings, and appeals. But at the end of it, she also got something else. A ruling that made sure the next person in her shoes would have a little more power and a little less to lose.